So, right, clients don't come in with a list of issues clearly.
They come in with a problem.
Right, and they just...
And they tell you what they want to tell you. And then you have to figure it out.
Right. Welcome to all our viewers here. We're at the Media Reporter at New York Law School, and we're talking today with Professor Ross Sandler and his wife, Alice Sandler. And we're discussing Professor Sandler's new book, Jumpstart, Torts, which came out in March 2012, and we're really glad to have you here. So thank you for coming in and talking to us. So we've been talking a little bit before, but I really wanted to discuss with you what made you write a book in this format for your students.
I've been teaching torts at New York Law School for 20 years. And when I first started, I thought, boy, I'd really nailed it. The students got it. And then I get the exams and they were confused. And I was trying to figure out why they were confused. And what I realized was that torts is taught to first-year students. They come in that August, they know they have not taken civil procedure, they don't know about law, and they need help to understand what it is they're supposed to learn. So then I started drafting my own materials to help students understand how to begin reading cases, how to think about law, how to understand the vocabulary. And it evolved into this, into Jumpstart, Torts. At first we called it the language of law. And the idea being that it's a new vocabulary, it's a new language, new use of words. Often similar words you use in ordinary speech have different meanings. So it's very important to think about that. And the combination of language and legal analysis led to Jumpstarts. And what it is what you need to know in order to begin to know what to study and what to write about in torts.
Right. And it's not just torts. I think that the principles that you go over and you outline for your readers are applicable across the board in any legal
application. Well, they are true. That is true. But torts in particular, because torts is all about litigation.
Right.
It's about injury law. Tort is you have an injury, usually between strangers. They don't have a prior relationship. So all you have is this injury event. And that then goes to litigation and all the courtroom procedures, all of the issues about complaints and answers and motions for summary judgment, all that is in play, and it's almost impossible to understand the judicial decisions that law students are asked to read from day one unless you understand that this is about court procedure, and that's what this teaches.
Right. I wish I had had this book as a tort student.
Well, you can start again. You want to start again?
Well, I have been. I've been thinking I can at least use this for the bar exam. So.
Well, good. And tell your friends.
I will. I will. And for all our viewers, it's available on Amazon.com. Again, it's called Jumpstart Torts. And I think that what's really interesting, Ms. Sandler, has helped you with this, and your background as an educator really comes through, because this is unlike most case books in that it really breaks down step by step what is required of students to do well on an exam. And so I wanted to ask you, what did you know that from what you had seen, you've seen a case book, you've probably seen thousands of them, and you realized that a little more needed to help students, or did you?
Just in talking with Ross and in conversation and hearing what his students needed and hearing that the difference between a plaintiff and whatever the other defendant is. You had to get those cast of characters,
right? Exactly.
and all the parts together, and you had to learn what each one was. And so Ross and I would talk about it together, and eventually he really did it.
I would write stuff, and then Alice would read it and say, well, I don't understand this. What does this word mean here? And so we'd have to go back. And so what Alice contributed a lot was what a good editor does, which is to say, you could make this clearer. You could write this so that people understand it better.
Right. And that's what's really stands out most to me, is that a layperson, not even a law student, could look at this and it would start to make sense, just because it's so step by step. It guides you, whereas a casebook just gives you the opinion and you're asked to make sense of it.
Well, what I looked at all the casebooks, and they all start off with maybe 10 pages or 15 pages where they try and tell the student, well, let me tell you what you're going to be learning here. And then you read that, and it's so dense, and it's so without examples, and so quick that it's almost unhelpful.
Right.
And then I suspect that what professors do generally is they say, read that, and we'll talk, and they don't talk about it. or they come back to it class by class, and so you spend a lot of time covering this kind of material too late in the term. So I think it's very important to get it early,
Right.
and then get it later, both early and later. Early because it gets you going, and later because you really understand it then.
Right, exactly. And that's what Jumpstart Torts really helps with. The glossary and the appendix breaks down what every word
Yeah.
means and how to use it without a 4-sentence definition, which you sometimes find and actually isn't very useful because it's just more to memorize.
Well, I wish students would look at the dictionaries more, but they don't. And so they come across words, or they think they understand a word. For instance, a term like summary judgment, that's understandable. It's a judgment and a summary, meaning that it's without a trial. People understand that. But what's behind that term is an enormous amount of knowledge, standards, procedures. And so you have to get all of that, because otherwise it's a code that students can't break.
Right.
You need to break down these words so it can be understood and then used.
Right. And it's impossible to use these words on an exam without having an understanding all year round. And I think that's what we were just discussing before. This shouldn't be a book that you buy 2 weeks before the exam. It could actually help you throughout the semester before.
Well, we included an exam in it. The publisher thought it'd be a good idea to actually include an exam, so I took one of my exams and I adapted it, and a rubric that I'd actually used, and then I went to the students who had turned in their exams, and I took one that was very good and one that was not quite as good, and I then put them in the book, and then I commented on each one of them in the margins as to why this one was good, why this one wasn't so good. And one of them, there were two plaintiffs, and they were different, had different fact patterns, and the exam that wasn't quite as good, the student had combined them. And so he missed all sorts of issues because they were in two different situations. So that's the kind of thing that students don't necessarily get.
Right.
Another thing, students, they like to write like lawyers, so they use things like a P and a D for plaintiff and defendant, and they use acronyms. And it turns out that that doesn't work so well in an exam, and it's obvious when you read it that they get mixed up.
And I think that also one of the valuable parts of this book is the exam grading rubric, where you really show where points are lost and made, and how to structure your answers in a way that can get you an A.
Well, most professors give out their old exams. Okay. So a student can look at an old exam and say, well, let me try and answer it, and then they may work together in a study group, and they answer the old exams. What most professors don't give, or many don't give, is an actual rubric on how they will grade it. So the student not only knows what the exam is like, but what the grading sheets will look like. So that's part of what other professors do it differently, but I do it with a rubric, very formal, and that way you need a rubric. A rubric is simply a grading sheet that tells you what you're looking for. Then you can use that to indicate whether what you find in the paper is there. I find it useful because you grade papers over a relatively long period of time, maybe over a week that you're grading papers, and you want to try and be consistent.
Right.
Although sometimes the first paper sometimes gets a very high grade, sometimes gets a very low grade. Then you go back and say, wait a second, maybe I didn't do right by the first paper.
Right, right. And also the combination of civil procedure and torts is really useful, because the way that it's taught is usually in a vacuum, or that's how I learned torts. Didn't really focus on any of the litigation issues, and that's what struck me about this book as well, that this could be used by a layperson who either had had a personal injury and wanted to know what lay ahead if they decided to press suit and follow up, or anyone who just might be in this situation where they need some more background information. It's not just students.
That is true, because it does fill in all the gaps.
Right.
You know, why is my case going here? Why are we having a motion? What are we doing? That answers all those questions. And law students need to know that as well.
Right.
They get mixed up in not knowing the various stages. Plus, in law school, you know, you only can take so many courses at once. Civil procedure sometimes is taught in the first term, sometimes it's not taught in the first term. And when it is taught, they teach a lot of things that are really important to know, but which are not geared towards handling tort cases or contract cases. They spend a lot of time on jurisdiction, long-arm jurisdiction, issues of whether the court's power, federal courts versus state courts, all of which are really, really important, but are not the kinds of things that lawyers with ordinary cases and ordinary courts spend a lot of time with.
Right.
And then I found that the students like cartoons, so we have cartoons in the book to help explain the cases, and those were done by a wonderful cartoonist, and we'd work together. I'd tell him what I wanted, and sometimes he'd give it to me, sometimes he wouldn't, so I send it back. There's one cartoon that a fellow is hunting, and he's apparently killed by a bull in a corral, and so the cartoon came back, and the bull was fabulous, but I couldn't find the dead guy. So I kept looking. I said, "You got to make him bigger."
Right.
So he said, "Okay." So you see his boots sticking out from under the fence, bigger, so you had to worry about accuracy. And then another case where a fellow who's very drunk is given a roast beef sandwich and immediately chokes to death, and so he sues the diner. And so have to have the roast beef sandwich exactly right. And so the idea is to make it so that the cases are memorable in order to memorize and understand the legal procedures and rules that come out of these cases.
Right. I think I've looked at many case law books, but this is the first that I've seen with pictures.
Yeah.
And really, it is helpful because there are people who learn through visuals, and
Right.
it helps. It's a memorizing technique, and
Well, some of the tort case books have pictures of the judges. Boring,
Right.
and I mean these guys in robes and wigs and things. And I don't think that's very helpful. Although you look at Judge Cardozo
Right.
and walking down the steps of the courthouse, and you know that he's a real person.
right, exactly. Not
But
just-
I think the illustrate the cases are better.
Right. And I think that what you're saying, the editing process for the images has not just been with the cartoons, but this entire book really started back in 2007. And you talk in the intro about how you've been getting feedback from students and incorporating the
Right.
feedback from the students. Into the
Hundreds
book.
and hundreds of students have
Right.
used these materials in various forms, and we'd always ask them to comment on them, and we get dozens of comments, and a lot of comments are in the back of the book. Students find it very useful. They appreciate that because it's a guidebook.
Right.
It really does help you navigate this first term of law school for them and for anybody else who navigates what goes on in a courtroom.
Right. And even if you've taken torts and you are preparing for the bar or any other class, I think this is really helpful.
That's a good reminder. Because again, a question like, does the plaintiff have a cause of action against the defendant for this injury? That's code.
Right.
I mean, first you have to know what the plaintiff is, you have to know the defendant, you have to know the meaning of a cause of action, you have to
Right.
know a standard for a cause of action, you have to know what a prima facie case is, you have to know what a theory of the case is. So we're constantly speaking in code as lawyers, and I guess that's the way we keep clients away from us, and why we can charge fees, but it's not very helpful to somebody who is trying to understand what's going on.
Right, and this decodes the language of law for torts
Yeah.
and makes it accessible for especially 1L students who don't have really any contact coming into a torts class or any other of their law classes.
Right.
So, yeah.
We have, here at New York Law School, I use this in the evening division, where you have a lot of students who are working, some of them in
Right.
law firms, and they're among the most enthusiastic about it, because their law firms don't teach them enough.
Right.
And so they're very happy that they're paralegals or secretaries or assistants doing something, or they're police or something like that. So New York Law School attracts a lot of people for whom this clarifies
Right.
things.
Right, and even from working in a firm, you might not still pick up on some of the more technical meanings. So even students.
It's all
who don't-
technical. Law is technical.
Right.
And it requires mental acuity, and it requires methodology. And if you don't learn it, you can't do it.
Right, and it's nice to have something like this book, which breaks down to the most fundamental level,
Yeah.
really the exact words, and makes it so that students can use those words and answer exams in a way that makes you happy to read them. So,
But more than exams, it's so that you understand the language when you're listening to lawyers talk. or when you're listening to any field.
Right.
If you take Music 101, you can learn what a concerto is, and you don't have to be a musician. The same with the Jumpstart Torts.
Right.
You really can understand your local newspapers
Right.
when they tell of an injury and tell of a lawsuit that's going to happen and the tree fell. And this puts it in layman's language,
Right.
which was the language that I was interpreting for Ross, and how we really, every time, make it more clear for the person who has no legal background.
Right.
And first-year law students generally have no legal background.
That's right.
They are, come in with no knowledge, and all of a sudden they're thrown into this, and that's what this was designed to help.
Right, and I think that's part of why this could even be valuable to not a layperson, not a student, not anybody with more background than just watching Law and Order on occasion.
Right.
It
There you
really
go.
is accessible.
Law and Order is pretty good.
Oh yeah, I do. I do like Law and Order. So.
Although it's pretty hard to do an entire criminal case in an hour. I mean,
Right.
generally it takes months and months.
Months, right? They make it seem so simple and easy, but so does this book, really, because I wanted to also talk about the Iraq format and that you break that down here. It was amazing. I didn't get an Iraq format till halfway through 1L. I would have been so.
May
Yeah,
I
of course.
interrupt? You're saying a word that somebody might think is in the Middle East.
Right, that's true. Right. So,
And they haven't got the code.
Right,
So I
okay.
think you should explain first.
So I is the issue. When you get a fact pattern, you're going to be expected to issue spot, and the next letter is R, and that's for the rule, and A is analysis, and L is
No, C is
C
conclusion.
is conclusion. So to wrap up, you want to wrap it all up before you move on to the next issue, and usually a student struggles with
Right.
15 or 20 issues in a fact pattern.
I like formulas. I like to have a formula, not because formulas give you an automatic answer, but because it gives you a starting point.
Right.
So the IRAC formulation is only one way to think about law, but it's one, and it's a formula. So it's a way of outlining. So there's you learn about the 5 or 7 paragraph essay. This is the same sort of thing, that it gives you a way of organizing an answer, a beginner to organize an answer, and then to do something that lawyers will understand and in the order in which they need to understand it. That's what it does. So IRAC is a formula. It is not it's not a computer that spits out an answer. All it is a way to organize an answer, but it's extremely important and very helpful to students, because the students, they have scrambled facts and they have scrambled arguments, and they don't quite know where to begin and which piece do you do first, and that's what that's about.
Right.
So that's what this book does too. And so here's where you start. Here's your entry point, and then once you get your entry point, then you can go forward.
Right, and I think for especially 1Ls who have never taken a law school exam before, it's difficult to emphasize how much pressure they'll be in under that testing circumstance. So to have something as simple as IRAC in your head can really be a guiding light.
I didn't invent that. I mean, that's
Right, that's been around
been a
for-
long time, and in some ways, a lot of professors don't like it because they don't want to be thought of as doing formulas. They don't have to use it, but for many students, it's really helpful to know where to start.
Right, and that's something I think in this book also, you emphasize that there are lots of different learning styles. You got to figure out what works for you, and you shouldn't sit down and take an exam for the first time on actual test day. You should be doing practice exams,
Right.
and that's what you give students
Right.
in your book.
Exactly.
So I'm trying to think what else that we... And also in the beginning, I know that the anonymous student forms that they fill out at the end, that we fill out at the end of the semester and give you feedback. Has that helped shape the way you teach?
Oh yes, because what the students say, you read very carefully because they're telling you something, and it's been very helpful in this book. We've used it in my class. Other professors have used it. They've asked their students to comment on it, and not all are anonymous. A lot of students will send you comments,
Right.
including corrections. So you're happy to get them because then it improves. And the first we've used this book first in like offset, and then we actually had it printed and in a sort of a fancy print job that we
Right.
did, and then finally Aspen came and said, you know, I think we'd like to do this. And so now we have it in this form, which is a form that will be sold around the country.
Right. And it's very rare to find a book that's less than 150 pages, especially for law. So it's not overwhelming by any means for students who are worried coming up. It's exams and they don't really want to read 400-page form book. This is it's really useful. It's really useful. And I also think it's important to emphasize that there's so much that a 1L has on their plate. So to have someone walking you through the process, much like this 147-page book, is great. I wish I would have had this, actually, so I can only emphasize to our viewers, anyone, even if you're a student or a layperson, that this could be of a lot of value to you. Is there anything else you'd like to
No, I
comment
think
on?
that this has been fun.
Yeah.
I love talking about it, and students seem to enjoy it, and I'm happy that you liked it.
Yes, I just wish I had it earlier. That can really be the only thing that I have to say about it. I think, and March 2012 it came out. It's available on Amazon now. Is it available in bookstores, at law school campuses?
Law school bookstores. Aspen will put it in law school bookstores.
Okay.
But and you can get it online. You go online, it's right there.
Okay. Again, thank you so much for watching. This has been Professor Ross Sandler and his wife Alice Sandler, and this is my name's Elizabeth D'Antonio, and this is the Media Reporter. Thank you.
Hello, I'm Johan Salin, and this is the Media Reporter. I'm a fourth-year law student here at New York Law School and a member of the Black Law Student Association. The Black Law Student Association, commonly known as BLSA, is dedicated to helping students of color by providing a friendly and supportive environment. Every year, BLSA holds an alumni dinner. At the 10th annual alumni dinner, the keynote speaker was the famous Johnnie Cochran. In the first clip I'm going to show you, Johnnie Cochran talks about the person who inspired him to become a lawyer, the late Thurgood Marshall. Mr. Marshall was not only the first black to serve as a justice on the U.S. Supreme Court, he was instrumental in the famous landmark case of Brown versus Board of Education. Let's take a look.
I'm an unabashed fan of a man I want to talk about tonight. And I want to speak to from the subject, Thurgood Marshall, as the ideal in the changing state of justice in America. You notice I'm wearing a pin today of Thurgood Marshall. And this morning I was at a LDF meeting. We had our LDF meeting, the Legal Defense Fund meeting this morning. And Thurgood Marshall's wife was there, Cecilia Marshall, and she's a marvelous lady. When I knew at a young age I wanted to be a lawyer, I looked around, and I didn't know many lawyers. I didn't have any role models to look up to. There was no lawyers on television who looked like me, and I didn't really know a lot about lawyers. But when I was in high school, I read one day on May 17th, 1954, about this remarkable lawyer, Thurgood Marshall, who changed America forever. And next year, on May 17th, it will mark the 50th anniversary of probably the most important case in the 20th century in this country, the case of Brown versus the Board of Education, which said finally that separate but equal was wrong, that it would be separate but equal is inherently unequal. And it changed the law. It changed Plessy versus Ferguson forever. And it put us on a path to get us where we can have an integrated setting like this. It made America better than it was. And so very often, when I'm faced with a difficult issue in my law practice, I'll ask the question, what would Thurgood do? And if you ask that question, and if you can answer that question, you will be on the right path very often. So I want to talk to you about this remarkable man. Finally, I want to tell you that last Monday, 2 Mondays ago, April 14th, they changed the name of the courthouse down here at Foley Square. It's now called the Thurgood Marshall Courthouse, and that's a remarkable achievement for this remarkable lawyer and a recognition of what you can do. You may come from humble beginnings, but it's where you end up at the end of the day. And he set a standard for all of us to follow. So as we gather here tonight, the greater world around us is in many ways in a sad state of affairs. The globe now turns with an undercurrent of fear. Insecurity abounds, a war just wrapping up in Iraq. Ethnic fighting continues throughout the vast homeland of Africa. Political coups are commonplace all over South America. Japan seems to teeter on a never-ending financial seesaw. Mysterious diseases traverse entire continents. SARS, we see AIDS, hunger, homelessness, and poverty in lands near and far. Meanwhile, here at home, we're thought of as the world's greatest superpower, but have a president who did not truly assume his presidency until September 11th. We have an attorney general who's willing to trade our personal liberties for homeland security. We have an economy that's gone from robust to bust, with disgraceful corporate scandals and obliterated personal savings. Daily headlines are filled with stories of child abductions, wife murders and disappearances, and even Mercedes murders. Now, I bring up these circumstances to remind you of one thing only, now more than perhaps ever before in our history as a nation. The notion of justice is vital to our survival. As minority students, law students, you all are familiar with the life and work of Justice Thurgood Marshall. Well, he was my hero because he stood for nothing if not for justice. Thurgood Marshall knew how he wanted to be remembered, and he explained it in the powerful simplicity that he was known for. Here's what he had to say: that he did what he could with what he had. He did what he could with what he had. For each of us here tonight, let's do what we can with what we've been given. That's my hope for all of us. May you continue to grow as individuals and as a people and give this world what it needs from each of you. If you think of Thurgood Marshall as I do, in your lives and in your work, you will always stay the course on the road to justice. Do that. If you do that, you'll transform this nation into what it is, into what it might be. A shining beacon on a hill that leads the example for the rest of the world. You don't just become a great nation because you say you're great. You become a great nation when all of our citizens have equality of opportunity, when they have a fair shot and a fair chance to go as far as their abilities will carry them. We can't rest till that happens, because I'm telling you, no matter how successful you are, none of us are free until all of us are free. And there are people tonight who couldn't be here tonight. We have to remember those people and make America a better place for them. What would Thurgood Marshall do? He'd fight for those people. We can do no less. Thank you, and God bless you.